This Law Shell case study will be addressing Baldwin versus Atlantis Water Solutions, LLC. Now, this is a case that was initiated out of the bankruptcy courts and ultimately was a appeal to the Ninth Circuit. So it was a federal appeal, which was determined in 2019. And while it may on its face appear that we are just dealing with a debtor and a creditor because we're coming from the bankruptcy court, in fact, there are much more significant issues here to be addressed, specifically dealing with corporate law and the limits of liability when the corporate veil can be pierced, as well as what the limits of liability are and how that corporate veil doctrine applies when applied to an LLC or limited liability company. The corporate liability shield is one of the primary reasons why individuals or other entities would seek to use the corporate entity as a business entity. It's one of the key benefits of corporations. A corporation is its own person. It's its own legal person. It may not have a heartbeat, it may not be breathing, but for business purposes, it might as well be. Okay, the corporation itself is set up in order to act as a separate individual out there in the world. And in doing so, because it's a separate individual, the individual owners of that entity, the shareholders, those who own an undivided part of the entity itself, are not responsible for anything beyond their investment. Their liability, their responsibility is limited to his or her investment in the entity. What that means is if the corporation is out there in the world and it is entering into contracts and then defaulting on those contracts or committing torts and being sued for damages, the shareholder, the underlying shareholder, is kept separate from that. There is a wall up between the individual shareholder and the corporate actions themselves. And the shareholder cannot then be held responsible or sued to personally pay back the debts of the corporation, whether they be from business activities that the corporation engaged in, whether they be from wrongdoing that the corporation is engaging in, whether they be from some sort of negligence or damages that the corporation incurred. The individual shareholder is not responsible to satisfy those. Only the assets within that entity are available to satisfy debts, not the individual assets of the shareholder or owner of the corporation. They are kept separate. There is a wall built between them. Certainly, there are some exceptions. If the shareholder was involved in committing those torts or engaging in those acts or contracting for those decisions that were ultimately unable to be repaid, entering into those contracts that could not be satisfied, if they were involved in committing those actions, then they could certainly be held liable. However, without a personal guarantee on their own or without their own individual actions, they were kept separate from the actions of the corporation. Now, this corporate liability shield, it initially applied only to corporations in the traditional sense. It applied only to the standard corporation as we think of it with shareholders. However, it has been applied later to other types of entities that specifically are set up, again, for that benefit of limited liability, to separate the liability for the business actions from the investment, such that the parties who are investing only in the entity cannot be held liable if they're not acting on behalf of the entity for anything beyond really their investment in the entity. That's always up for grabs. That's something that if the entity fails or the entity is held responsible and its assets are attached or it's required to pay back debts, then the shareholder or partner or member's investment could be used to satisfy those debts, but they're not going to be individually sued for anything beyond that point. So certainly this has been later applied to other types of entities, limited partnerships, LLCs, other entities altogether. So again, that corporate barrier, that division between the corporation going out there and acting in the world and potentially getting into trouble And its underlying shareholders is one of the major draws of using this corporate structure. It's this separation, knowing that the investment in the corporation is all you have at risk as a shareholder can be very comforting, as well as good business, knowing that the activities of the corporation will not subject you to personal liability is one of the reasons that you enter into this kind of business arrangement. We call this separation, this division between the liabilities of the corporation and the activities of the corporation and the activities of the individuals, the corporate veil. It's something that separates and hides from the corporate side of things the individuals who are the individual owners of the corporation. Now, piercing the corporate veil is when the courts will look behind that barrier and they will impose liability. They will ignore this shield that the corporation holds up to protect its inner shareholders, and it will impose liability on them. For example, hold them responsible for the wrongdoing of a corporation, whether it be financial wrongdoing, failing to maintain its debts, or some sort of tort liability, whatever it might be. So piercing the corporate veil is when the court ignores this barrier that the corporate entity creates from its shareholders and instead imposes liability on them. Now, this happens less often in larger corporations. It happens more often in smaller corporations. We'll kind of talk about why. But in larger companies, we tend to see this in cases involving watered stock. And watered stock is sort of an interesting term. From the corporate perspective, it deals with stock that's being sold at inflated values. It's being sold well above par value. It comes from actually the term stock when thinking about cattle. When cattlemen or cattlewomen would sell stock at auction, they'd sell their animals at auction, typically for meat. They would sell them based on their weight. And so what watered stock refers to was a term where it was a term where the stock in the days coming up to auction would be fed a lot of salt. And so they would drink a lot of water because that would be the natural response. And drinking all that water meant that when they weighed them to determine the price for them, they would come out heavier. And so the cattlemen or cattlewomen, whoever was selling the stock, would end up getting more money for their stock. And so that actually is kind of where the term comes from. It deals with an overinflated value of the shares, overinflated value of the stock. We also see it sometimes when there's in a relatively small company, there's liability for wages, where the courts will look behind that liability shield in order to find that liability. But usually piercing the corporate veil is a doctrine that's invoked. It's something that comes into play when we're dealing with a very small company where we can see all the actors. We're not usually talking about a publicly traded corporation that is out there in the public and it has thousands or millions of shareholders where stocks are being traded on the open market daily. This is going to apply. We're going to see it much more often when we have a small company where we can see the individual actors who are using the corporate entity, but potentially are using it as an alter ego of themselves. So when we have a small enough company where the individual shareholders are identifiable and they might not be maintaining the separation necessary, the separation between themselves and the business entity, which gives rise to this reason behind the barrier, the reason behind the shield. When they start blurring the lines and they start acting as though they're the alter ego of the company, the shareholders may find themselves then not being able to benefit from the protective shroud, the protective shield, the corporate veil, if you will. So a lot of the times where we're looking at piercing the corporate veil or whether or not it's appropriate, whether the court is looking to do so, we're looking at factors like whether or not the corporation was really kept separate from the individuals, whether the corporate formalities were being observed. This can be key. Were you dotting your I's, crossing your T's, and keeping the corporation separate from yourself? Or were you blurring the lines as one of only a handful of shareholders, where you were treating the corporate accounts, the corporate entity, as though it was simply an extension of you? So again, the corporate veil, this corporate shield that protects the individual owners of the business, the shareholders, from the actions of the corporation, is the corporate veil. And traditionally, this was applied to corporations and corporations only. This was the traditional business entity that creates its own independent legal person out there acting in the world. Now, all corporate law is typically going to be based on individual states. Each individual state has its own substantive law that addresses business entities and specifically corporations, but we will see some themes throughout. As we indicated earlier, again, the corporate veil was originally only applied to traditional corporations. This was the business entity that creates an independent person acting alone. In order to create a legal person that's out there doing business in the world, there's a lot of formalities that are required. No corporation is born by accident. It doesn't just happen. You don't just start doing business and voila, there's a corporation. You need to obey the formalities, you need to follow them, and frankly, there's quite a few of them. So you can't accidentally create a traditional corporation. It has to be intentional. In order to do so, you have to create actual documents to form the corporation, to incorporate, to create from nothing this legal person. So there's a little bit of magic involved. There are articles of incorporation, etc. You need to elect directors. You need to put people in charge, directors who are ultimately going to be following the corporate rules, ensuring that the formalities are put in place and maintained, who are going to be voting on changes to the corporation, who are going to be amending or following the articles of incorporation. You need to keep a separate set of corporate books and bookkeeping. You don't just throw everything through your personal account. Again, if a corporation is a separate legal person, and that separate legal person's liability and obligations and wrongdoing do not belong to you, they can't just be an extension of you, and you can't just let them have a debit card out of your account and you have a debit card out of theirs. They have to be maintained as a separate person. Now, sometimes it helps, I think, to think of that corporation as its own individual, its own living, breathing person. And while it's not living and breathing, its heart is not beating, it is a separate entity. And in order to treat it that way and take advantage of that protection, that separation of liability, that formality needs to be maintained. And that includes keeping separate corporate books, not paying personal bills if you're a director or shareholder, not paying personal bills out of the corporate account, not paying corporate bills out of the personal account, keeping that separation. Now, one of the key components of a traditional C corporation is double taxation. So the corporation is taxed at its own individual corporate level as an entity itself. And then when its profits are distributed to its shareholders through the form of dividends, those shareholders would then report those dividends as their own income, and they would then be subject to another levy. That those would be included in their income and they would be taxed again. So that's what we commonly refer to as the double tax problem with corporations or with C corporations. Again, taxation is a little different with different types of corporations. You might see a subchapter S corporation, which is taxed differently, but with a traditional subchapter C corporation, which is what we're talking about here, we do have those two layers of tax. One layer of tax at the entity level, the corporation files its own return, pays its own income taxes. Second level of tax when any profits, earnings and profits are distributed to the shareholders in the forms of dividends, at which point they're included in the income of the shareholder and tax is then levied on that. Now, there are also professional corporations. Again, each state may have its own set of rules specifically authorizing this particular entity or not, and what the requirements are for these particular entities. However, generally speaking, a professional corporation is similar to a C corporation, but it does avoid double taxation. It does avoid that second level of tax, but it's available to only certain types of businesses, usually where the professional services are pretty much the entire value of the corporation. For example, common with doctors, sometimes with attorneys, etc., where truly the value of the corporation, the income that's brought in, is based on professional services. A limited liability company, or LLC, has become common in the last, well, several decades, really, and it's authorized in a number of states. It combines in some ways the limited liability of the corporate entity, but it combines that with and avoids the double taxation issue. So it combines it with a single flow-through taxation, potentially avoids the double taxation at the entity level, and then upon the earnings and profits in the form of dividend with respect to its members, in that case, not shareholders. An LLC in most states would be available to anyone. You don't have to be a certain profession. Your entity does not have to be primarily generating its income through situations like professional services. So it can be available to anyone doing any kind of lawful business potentially. And it doesn't have the same corporate formality requirements. Now, again, a corporation has a lot of formal requirements, a lot of paperwork that needs to be pushed, regular registrations, regular meetings that need to be held. The limited liability company, or LLC, is a much more informal entity. Once it's created, it has very little in the way of formal requirements, very little in the way of voting, very little in the way of documentation in the same way that a corporation does. However, all three of these entities do share that corporate barrier, that corporate veil, that limited liability that makes them so attractive as a form of business to use. So before we get to the Baldwin case, where we are going to talk about piercing the corporate veil in terms of limited liability companies, we're going to need to talk about piercing the corporate veil as it applies to corporations. And to do so, we're going to talk about the Peschel case. The Peschel case was Peschel Family Trust versus Colona. This was a Montana Supreme Court case. And again, this was a case involving these issues of state law, which corporate law is, in Montana, and it involved piercing the corporate veil with respect to a Montana professional corporation. And the facts basically lined up as these. Colona, who was the defendant, set up a Montana professional corporation for his dentistry practice. Remember, there are specific corporations that can only be created and entered into and run when they deal with certain professional services. And in Montana, the dentistry itself was the type of professional service that could qualify to set up a professional corporation. These are business entities, corporate entities, where primarily the value of the corporation was in personal services in certain fields. Dentistry counted as one of them. Now, Dr. Colona, the dentist and defendant in this case, he and his wife were the original directors of this professional corporation, but the marriage didn't work out, things fell apart, and they got divorced. So she left, and at a certain point, Colona basically became the sole everything. He wore all the hats. There was nobody else. So he had this professional corporation, but he was the only one acting. There was nobody else involved. So again, we can see the lines are getting a little blurry here as far as where the corporation ends and where he begins, and whether or not there's overlap between the two. So Colona, through his professional corporation, leased office space from another dentist in town who technically owned that building and that office space in his trust. And that was the Peschel family, and this was in the Peschel Family Trust. So they were the plaintiff in this action. As you can see, things broke down fairly quickly. Now, Colona had a disagreement with the plaintiff. Again, who knows why? They were all dentists practicing in basically the same place, so we won't know what happened, but regardless, the ultimate agreement broke down and he left the building and he rented other space after they'd had some sort of disagreement. Now, when he vacated, his company stopped paying rent. Peschel sued for non-payment of rent. They sued to enforce the contract and they sued the company, but the company had no money. The company had no money to pay its obligations. The plaintiff then, Peschel, asked the court to hold Colona personally liable by looking behind the corporate shield, looking behind the distinction between the professional corporation and Colona himself, and by piercing that corporate veil to hold Colona responsible for the debts of his company. So the court considered a number of facts that were relevant according to ultimately the trial courts. First, Colona used the company to sign the old lease with Peschel. It's the company that entered into the lease with Peschel for office space. But then he used his own personal money to buy a new building. And the company then entered into a lease with Colona himself. So again, remember, it's Colona wearing the company hat, entering into a lease with himself wearing his own individual hat. The company then paid Colona's mortgage payments to the new building directly to the bank. So there was no middle ground here. It went directly to the bank. The company paid Colona's individual mortgage payments because he owned the mortgage, or he owned the business and therefore paid the mortgage, owed the mortgage himself personally on the new building, and the company paid that bill every month. It sent a check for him. Colona made a series of loans to the company to allow it to pay its rent, again, to him. Keep in mind, which hat is Dr. Colona wearing when he's making these different actions, when he's doing these different things? What hat is he wearing? And is he wearing both? Is there any distinction truly between the two? Colona then used corporate money from the business to pay his personal expenses. The company paid for his truck. The company even sponsored his bowling career. Now, during all this time, remember, corporations have a number of formalities that they need to abide by, that they need to obey to show that they're actually their own entity. This company only had 3 corporate meetings in 9 years. Now, however unbelievable it is that Colona would put on his corporate hat to have a meeting with himself regularly, it was still supposed to happen in order to maintain that separation. The corporation had to do its own business, and it only did its own business and had a meeting to address corporate matters 3 times in a period of 9 years. So again, the Peschel Family Trust, plaintiff in this action, asked the court to look behind the veil, to look behind the barrier, to see that the corporation was truly Colona and Colona was the corporation, and therefore he should be held individually responsible because, again, the professional corporation, the company here, had no money. It was undercapitalized. There was not enough money to go around to pay the debts that were owed under the broken lease. So in looking to see whether or not to pierce the corporate veil, the Montana court gives us a 2-prong test. The first prong of the 2-prong test was that the trier of fact must find that the defendant was the alter ego, an instrumentality or agent of the corporation. That when the defendant was acting, he was truly acting as an extension of the corporation and vice versa, potentially, that they were truly one and the same. And then second, the trier of fact had to find evidence that the corporate entity was used as a subterfuge to defeat public convenience, justify wrong, or perpetrate fraud. So not only must the defendant be the alter ego, they must be two sides of the same coin, but there must be evidence of some sort of wrongdoing, some sort of misleading or intent to perpetrate fraud or wrongdoing of some sort, something to defraud the public, something that just was not on the up and up. So let's look at the alter ego prong first. And for this prong, the court provides 14 factors. Not all of these need to be met. They just all need to be considered potentially, and they don't even all need to be present, but they do provide 14 factors that the court can consider in order to determine, first of all, if that first prong is met, if the company is an alter ego to the individual. So first, whether the shareholder owns all or most of the corporation's stock. Is this something where ownership is distributed across a wide span of shareholders, or is this truly one or a couple of people who are owning the company and acting in its stead? 2, whether the shareholder is a director or president of the corporation. Do they hold power? Do they have authority? Can they make decisions? 3, whether the shareholder makes all the corporate decisions without consulting the other directors or officers, of course, assuming there are some. 4, whether the shareholder, officers, and/or directors fail to comply with the statutory requirements regarding the operation of the corporation. So are they following the formalities? Are they following the statutory requirements of the corporation altogether? 5, whether the shareholders' personal funds are being commingled with the corporation's funds. Are we keeping separate books? Are we keeping separate accounts? Or is everything in the same cash drawer? 6, whether the shareholder's personal credit and the corporation's credit are used interchangeably to obtain personal and corporate loans. Similarly to whether or not you've got your hand in the cookie jar at work or your hand in the cash drawer at work for petty cash, are you keeping your personal credit and the business credit separate? Or do you individually take out loans on behalf of the corporation and vice versa? We're looking for that separation or lack thereof. 7, whether the shareholder's personal business records are not kept separate from the corporation's business records. Again, are we maintaining the separate nature of the entity, or are we blurring the lines? 8, are the shareholder and the corporation engaging in the same type of business or not? Are they truly opposite ends, or are they doing the same thing? Is there any difference between what they do, or are they just wearing different hats to engage in the same activity truly? 9, whether the shareholder and the corporation have the same address. And is this the address of the shareholder's personal residence? Again, how real is this business entity? Or is it, again, just another hat that the individual is wearing? 10, whether the shareholder admits to third parties that the shareholder and the corporation are one and the same. Doesn't always happen, but is that how they're referring to themselves? Have they acknowledged this to other parties outside? 11, whether the corporation's profits and earnings are distributed through means other than dividends. Are there distributions that are not going through the traditional share of earnings and profits through the corporate formalities? Is the shareholder taking draws that aren't tracked in the normal course of events according to a corporation? 12, is the corporation undercapitalized? Does it not have enough money to run? Does it not have enough money to pay its bills, the bills that it's incurring, the debts that it's incurring? Is that because the money is all held personally by the shareholder? Something to keep in mind. 13, do the parent and the subsidiary, if we have multiple corporations, we have a parent corporation and a subsidiary corporation, do they have the same name? 14, Do the parent and the subsidiary have the same directors and officers, the same group of individuals who are responsible for everything, who have control for everything? Again, not one of these is necessarily determinative. So again, once the 14 factors have been considered, the court must make a determination as to whether or not the corporation or the company is truly just an alter ego of the individual. And in this particular case, ultimately, they did determine there was sufficient evidence to conclude the company was Colona's alter ego. They were two sides of the same coin. They were different actors doing the same thing, one person wearing two hats. It was important to the court that there were only 3 meetings held concerning corporate decisions over a 9-year period. Again, why consult with yourself? Dear self, what shall we do? Oh, I don't know, self. What shall we do? Nonetheless, this was a corporate formality that needed to be upheld, and the fact that there were only 3 meetings over 9 years was certainly a factor that the court considered in determining whether or not the alter ego doctrine did apply. Colona further exercised absolute authority over all corporate activities as the sole director and officer. He was the only one. The buck stopped with him, and there were no checks and balances. Colona was the corporation's sole shareholder. He was the only investor. He was the only one here, the only one to make decisions and the only one to check on decisions and the only one to balance decisions. So in effect, no checks, no balances. Everything started and stopped with him. He was making loans to the corporation, and he was making loans of significant sums of money, indicating that the corporation didn't have enough money to meet its day-to-day obligations. The corporation couldn't run. It was really just a funneling bank account for him. It could not run on its own. If it were truly an individual entity, it would be acting on its own. Payments that were being made directly from the corporate accounts to pay Colona's personal obligations, and they were characterized as though they were loan repayments, but there was no intermediary step. The corporation was simply paying his bills, or more appropriately, after the court's determination as far as the alter ego application, Colona was paying his bills using the corporate checking account. There were no records showing that Colona was an employee of the corporation or that he ever received any wages. So truly, this was just a separate account for Colona. He was not being employed by the corporation. They were not sending out wages in the form of employment wages, that he was not even receiving independent contractor sums. There were no potentially withholdings for his employee taxes, and he was not receiving wages at all. So truly, what was he doing for the corporation? He was, however, personally benefiting from suspect corporate transactions. Again, the corporation was leasing a vehicle from him, and he was leasing out to the corporation his own property. And again, let's not forget his bowling career, which is being funded by the corporation. All right, so again, the Peschel court gives us a two-pronged analysis, and we need to address both prongs. So the first prong is, was the individual and was the corporation truly just an alter ego of each other? Were they one and the same? The second prong, if that is the case, after analyzing the factors, that the court comes to the determination that the corporation is merely the alter ego of the individual, well, now we need to look to the second prong, which is, once we've established that the alter ego is there, that they are one and the same, they're two sides of the same coin, they're two halves of the whole. The plaintiff then has another burden. They must show that there was subterfuge to defeat public convenience, justify a wrong, or perpetrate fraud. So there was something that was dishonest. There was some sort of clouding of the waters that was there for some kind of wrongdoing. Now, the court in Peschel held that this prong was certainly met, as Colona's actions were in bad faith. The company was always undercapitalized. It never had enough money to pay its bills. And so it was inherently unable to pay the rent unless Colona perpetually loaned it money to keep it afloat. Colona, according to the court, Colona wanted to have his cake and eat it too. He seeks to personally profit from renting his property to the corporation and at the same time protect himself with the undercapitalized corporation. So he wants to profit from renting his property to this business, and then he wants to use this business as a shield to protect him. There were so many suspect corporate transactions, and in these transactions, Colona was receiving personal benefits. The corporation entered the new lease for the new space with Colona as soon as it left the trust building. So by using the corporate entity, Colona was able to charge his corporation rent for a building he owned himself on a sliding scale. This is not an arm's length transaction. No business out there in the world would have likely entered into these transactions with Colona, except for the one that Colona had full and total control of, that was merely an alter ego of himself. So this in turn enabled him to make sure that his corporation would never have sufficient assets to satisfy the trust's judgment. So in walking away from the lease, in breaching that contract, he knew that never would his corporation ever have the funds to be able to pay any judgment against it. And the nature of the loans that he made ensured the corporation would never have any of its own money in order to satisfy any judgment against it. So he effectively ensured that it remained undercapitalized. There was never any money in it. He kept the money personally, yet he sought to use the corporation as a shield for himself. So ultimately, what was the result here in the Peschel case? Ultimately, in case you couldn't tell, perhaps by my intonation and where we were going and how the appellate court characterized the facts that they were looking at in evaluating the 14 factors, the result was this. Ultimately, the court found that there is sufficient evidence to support the district court's decision to pierce the corporate veil and to hold Colona personally liable for breaching the lease with the trust. However, it's important to note that there is a significant dissent here, and the dissent's opinion is delineating that there hadn't been an adequate finding of bad faith, and in particular, focusing on the undercapitalization is one of the factors that the court significantly held on to as demonstrating bad faith. Again, what is undercapitalization? Undercapitalization is not having enough money in the business to run, to operate, to pay its bills. And the dissenting judge believed that that in and of itself was perhaps faulty reasoning, because if bad faith means that the corporation, undercapitalized from its inception, has incurred debt which it may not be able to repay, then I suggest that the owners of countless startup and young enterprises are acting in bad faith, and will be surprised to learn that these circumstances could expose them to personal liability. Again, what is the dissenting judge saying here? Most businesses, when they start up, they are just trying to make it to the end of the month. Most businesses, when they start up, don't have enough money to run. Most businesses, when they start up, young enterprises, new enterprises, small businesses that get going, are doing the best they can usually to get off the ground. And if it turns out that this undercapitalization from the time that they are created, from the time the business is started, is enough to show bad faith, then the court, at least the dissenting judge, is concerned that many new businesses will be very surprised to see that just the fact that they're starting a business, usually from the ground up, which means from nothing, that could expose them to personal liability. Being undercapitalized from its inception, again, this is a common business problem. It doesn't necessarily infer improper motives on the part of the corporation's principals. In fact, it's how most businesses start, at least with small business. So there is that significant concern on the part of the dissent. And so this brings us to the Baldwin case, which is the case that we're focused on today. Now that we have the background as far as Montana's law on piercing the corporate veil and the backdrop of the corporate doctrines that are involved, we can look at the situation here in Baldwin and the factual background. Now, this was a situation that arose again in Montana. Now, you'll note that the appellate decision is from the Bankruptcy Court in the Ninth Circuit, which is federal. However, because corporate law and business law is a state set of laws, we still look to Montana law to understand and apply the nature of what's going to be determined here by the court. So Baldwin, well, the two Baldwins, Steve and Sherry Baldwin, owned land with river access in Montana. And Iafina Resources, Inc., they wanted to build a freshwater depot in eastern Montana to serve oil and gas company operations on the river land that was operated by Baldwin. So basically, Iafina established Atlantis Water Solutions, LLC, a limited liability company, to run this operation. Now, remember, as we discussed earlier, while the corporate veil doctrine and the separation and limited liability applied originally to traditional corporations, it's been extended over the years to a number of different entities, including limited liability corporations, as we discussed earlier. So Iafina established this LLC to run the specific part of its operations. Now, you'll note also that unlike our most recent case, the Peschel case that we draw from the background and we use as precedent here, Iafina is itself a business entity that established an LLC. The corporate veil doctrine and piercing of the corporate veil, again, can apply both to individual shareholders as well as entity shareholders. So Iafina Resources Incorporated was itself a corporation that created its own LLC, a subsidiary type entity, but the mechanics run the same way. So Atlantis Water Solutions LLC, again, is a wholly owned subsidiary of Iafina. So they own it in its entirety, but it is a separate entity. Iafina's chief operating officer, Dorn, was designated as Atlantis's president and signed documents on behalf of Atlantis in that capacity. In that capacity, Atlantis entered into a 10-year lease to use Baldwin's land and occupied it for years while it sought to get a water permit to operate. The nature of its business was going to be building a freshwater depot, and it needed permits and the appropriate approvals in order to do so. So it signed a lease and it occupied the land while it began applying for those permits to operate. During that time frame, Atlantis paid Baldwin about $459,000 in lease and other payments during these years. As you go through the case, you can see that originally they had purchased an option, and then when the permit process took longer than they thought, they paid to extend that option, and then they moved forward, typically trying to resolve the process to be able to operate by appealing to the state to be able to get the licenses that they needed to. Ultimately, they couldn't get a water permit, despite the extensions they requested from the Baldwins and paid for, despite the fact that they had been paying for the lease on the property for a period of time when those options expired and the Baldwins asked them to move forward. They continued to apply for the appropriate permits, but subsequent to their application and subsequent to entering into the lease agreement, the state had an environmental policy change and they were unable to obtain those permits. It just wasn't going to happen. They appealed their denials. They took every reasonable step, but ultimately they lost. And so there was no way they were going to be able to engage in the business that they had intended to engage in when they initially set out to enter into this contract, this lease agreement. Now, once they'd lost the appeal, Atlantis had no way to make money. And so, well, it stopped making the lease payments and it declared Chapter 7 bankruptcy. It had to liquidate. It had no money coming in. It had no means of making money. It stopped making payments and it said, we need to basically just call it. Baldwin sued for the over $700,000 in remaining lease payments under the terms of the lease. And ultimately, because of the bankruptcy, that's how this ended up in bankruptcy court. So the lawsuit ended up following them to the bankruptcy court because Baldwin was a creditor, Atlantis was a debtor, and it was unable to meet its obligations. And so this ended up being resolved in the bankruptcy court. So what was the issue here? Ultimately, we know, because we've been looking at the corporate doctrine of piercing the corporate veil, we know that Atlantis, the entity, the LLC, had no money. And so the only way that Baldwin could potentially recover here was going to be to try to hold Iafina liable for the lease. They were going to ask the court to look beyond the corporate veil, to pierce it, to look behind it. Basically, since Atlantis was an LLC and Iafina was the only member of that LLC. Now, again, slight distinction between our Peschel case, which was a corporation, a professional corporation, where Colona was the sole shareholder. With an LLC, we use slightly different terminology. The owners of the entity are called members. They have membership interests rather than shareholders who own shares, as would be in a corporation. But again, in substance, we had an entity that was wholly owned by one person, Iafina being a legal person, it's a corporation, as we did in Peschel, a professional corporation owned entirely by one person, Dr. Colona, the dentist. So the plaintiff, Baldwin, argued that the corporate veil needed to be pierced, arguing that the two-prong test from Peschel was met, specifically that Atlantis was the alter ego of Iafina. They were one and the same. They were Dr. Jekyll and Mr. Hyde, depending on what day you caught them on. They were two sides of the same coin. They were one person putting on a different hat. And so truly they were one and the same. And the second prong, that Atlantis had been set up out of subterfuge, so dishonesty and smoke and mirrors, and in order to commit fraud by avoiding responsibility for the lease that it entered into with the Baldwins. Now, the defense, Iafina, argued as follows: that first, the two-prong test shouldn't be applied to LLCs, and even if it is, the prongs are not met here. The court ultimately ruled for the defense, and Baldwin appealed, and that's how this ended up in the Ninth Circuit. So ultimately, it was the Peschel case that applied to Baldwin, and the application of Peschel was based on the fact that even though we were in a federal court, bankruptcy is a federal matter, and we're in a federal appellate court, Montana law applies. Peschel was a Montana case, and it was a Montana Supreme Court case. Why? Again, corporate law, business law is a state law issue. And so the Peschel case and other Montana Supreme Court cases control the substance of this dispute. And the key points that we have here are, first of all, that the Baldwins failed to establish that Iafina used Atlantis as a subterfuge. There was no smoke and mirrors or dishonest motives to defeat public convenience, commit a crime, or justify a wrong or perpetrate fraud. Remember, that was the second prong of the Peschel test for piercing the corporate veil. Ultimately, the Baldwins admitted they had no reason to believe Iafina used Atlantis for these purposes. This wasn't truly a bad faith case. In fact, if you go back to the appellate court's evaluation of some of the trial court record, it appears that it was identified that the Atlantis LLC worked regularly with the Baldwins to apprise them of the delays that they were having. They worked with them to request extensions. They seem to have been very upfront with the fact that this was the business that they were going to be into, and they were making every effort to get into that business. They simply were not successful at obtaining the appropriate permits. And again, the Baldwins ultimately admitted that Iafina was not being deceitful and that the defendants were not out to cheat them. This was not intended to be a way to scheme anybody out of money or to avoid doing business that they'd set out to do. It appeared that they were making their best faith efforts or good faith efforts to accomplish the business that they were looking to do in the first place. Now, according to the plaintiffs, though, they argued that the wrong that occurred here was decided at the time that there was an undercapitalized shell LLC that entered into the contract with them. So the Baldwins argued that it was enough of a wrong that Iafina created a shell LLC that didn't have enough money to pay any debts that it was incurring on that lease, and that the sole purpose there was to avoid liability for the lease. Now, the only thing that Atlantis ever did in this case, aside from sign agreements, was create protection for its sole member, Iafina. That was the only thing it actually accomplished. So the Baldwins argued that there was that in and of itself was enough to establish a wrong, that they created an entity that was only there to shield liability because there's no way it could have satisfied a judgment for the term of the lease that it entered into at the time of its creation and at the time of signing the lease. Now, while there was no evidence of intent to avoid Iafina's bad faith is demonstrated by the undercapitalization of Atlantis from its inception, and this by itself, according to the Baldwins, provides a basis for the LLC veil to be breached effectively. Now, in Peschel, the Montana Supreme Court noted the creation of an undercapitalized shell subsidiary that was not capable of satisfying any sort of judgment for breach of contract would be sufficient to satisfy the requirements of the second prong, the bad faith type prong. So the Baldwins were relying on this and saying, look, we've got it in the bag here. The wrong is complete based on the fact that this undercapitalized shell that couldn't have satisfied any type of judgment for what it was entering into if it didn't perform was in fact created, did in fact sign the agreement, and there was no way they would have been able to satisfy a judgment. Now, the court's response to this was that Peschel was found to be distinguishable. It was found to be a different situation. So in Peschel, the sole shareholder, Dr. Colona's intentional conduct caused the corporation to be perpetually undercapitalized and incapable of paying a judgment. Remember, with Dr. Colona, he was having the corporation pay his debts. He was having the corporation pay his mortgage. He was keeping the corporation from retaining any of its monies, and he was simply loaning it enough money as necessary to keep it afloat and taking draws from the corporation that were not trackable to any kind of actual wages or bona fide earnings, but instead just taking draws as he would to ensure that no money remained in the corporation. Now, Colona lent the corporation money so that it could make lease payments to him, truly. So he just kept moving the money around. It was like a game of three-card Monte. And that was distinguishable from what was going on here. Dr. Colona's record, of course, was also full of suspect corporate transactions. Again, remember, Dr. Colona was having his corporation pay for his own personal expenditures. It was paying for his bowling league expenses. It was paying for his bowling career. It was paying for his personal truck. There were no doubt a number of other personal expenditures that were being paid by the corporation in addition to those identified as specifically significant in the court record itself, but ultimately, he had his hand in the cookie jar and he had the corporation paying his bills, his personal bills, when it didn't have the money to pay its own. Now, in this particular case, in the Baldwin case, on behalf of Atlantis, there was no bad faith or egregious conduct. There was no bad faith or egregious conduct on behalf of Iafina. In fact, the undercapitalization issue, which the Baldwins hold out as a smoking gun here, enough to basically say that this should be enough to show that it's a wrong, is not enough. And in fact, you'll see the court's analysis is very reminiscent of the dissent in Peschel. The plaintiff relied on the fact that Atlantis never had resources in its own right to make the lease payments. So the true issue here that the Baldwins relied on is the undercapitalization, and whether undercapitalization alone is enough to establish fraud for purposes of piercing the veil of an LLC under Montana law. That's the issue. Now, the Montana Supreme Court doesn't directly address this issue. Instead, they say no, an LLC doesn't require the same corporate formalities of a corporation. Remember as well, this was an issue in the Peschel case where Dr. Colona had 3 corporate meetings in the course of 9 years. He didn't abide by the corporate formalities. So the court here in Baldwin kind of dodges a little bit and says, first of all, we don't have the same formalities in an LLC. It doesn't have the same meeting requirements. It doesn't have the same election requirements that a corporation does. But they also say for undercapitalization to justify piercing the veil of an LLC, it needs to be coupled with evidence of intent at the time of the capitalization to avoid future debts of the LLC. And this wasn't necessarily from the Peschel case itself, but instead they looked to courts from other states for guidance in this respect. Now, again, though, the court did heavily quote the dissent in Peschel, that undercapitalization alone shouldn't require piercing, because again, most startups, most businesses when they get going, most businesses when they start are undercapitalized. To start a business, you're usually running on empty and you're hoping to get off the ground. In an ideal world, you would be well funded and well capitalized, but so many small businesses, especially individuals who are starting businesses, do not start off well capitalized. So ultimately in Baldwin, the result was that the court found that there was no wrongdoing and that it was inappropriate to pierce the veil in this particular result. So the court found that Atlantis complied with Montana law governing LLCs. Again, they did distinguish the corporate veil and when it should be pierced with respect to an LLC as opposed to a corporation. But they did identify that Atlantis's business model was dependent on receiving a water permit, and Iafina infused adequate capital into Atlantis for it to satisfy its obligations for 3 years. Interesting to note that the Baldwins were paid almost $460,000 during this time period. So Atlantis and Iafina indirectly was addressing its obligations under the lease until it became futile. And they stopped paying the Baldwins only because, despite their best efforts, they were denied the permits that they needed. And then the state courts affirmed the denial. There was no way for them to enter into the business, to engage in the business for which they were set up. And it does not appear that there's any doubt that the Baldwins were aware that this was what they were set up to do. This was their purpose. It was not as a result of intentional undercapitalization. This was not a situation where Iafina was pulling money out of Atlantis in order to avoid having it have the assets to pay its lease. In fact, Iafina was infusing Atlantis with capital to satisfy its obligations and pursue the permits that it needed to do. The undisputed facts could not establish Atlantis was being used as smoke and mirrors or a game of 3-card Monte. It was not a subterfuge to defeat public convenience, to commit a crime, to justify a wrong, to perpetrate frauds, or to avoid any personal responsibility. Nobody was doing anything wrong. Unfortunately, the fates just did not align. They could not get the permit to do the one line of business, to engage in the one line of business that they were set up to do. Furthermore, one thing we need to keep in mind is this doctrine, this rule about piercing the corporate veil, going behind the shield that's set up by the entity, saying, even though there's this shield here, even though the veil is there to hide the individual or the underlying owners from liability, we're going to look behind it because it's just not fair. When you see that kind of rationale, it's important to remember that this is an equitable remedy. The ability for the courts to look behind the veil, to pierce it, to say, we're going to dispense with the formalities, we're going to dispense with the form, and we're going to look at the substance of what's going on here. That is an equitable remedy, a remedy in fairness. And in this case, the court identifies that the equities don't favor the plaintiffs, the Baldwins. In this case, piercing the corporate veil, an equitable remedy is there to curb injustices when you improperly use a corporate entity, when you try to gain an advantage and protections and engage in wrongdoing that you can't be caught for because of the form of the corporation. Well, then here we have a remedy to look behind that. But that's not what was going on here. The only party who gained anything from Atlantis's activities and the parties' agreements were the Baldwins. The Baldwins gained almost $460,000 from the agreements. Their land was never used because Atlantis could never get access to the permits that it needed in order to do business. And so the Baldwins were paid under the terms of the lease as long as Atlantis could justify pursuing that matter. They never tried to improperly act. They never tried to get a better deal, and they never tried to hide anything. They just ultimately, despite their best efforts, could not get the permits that they needed to do the one line of business they were set up to do. And at a certain point, it became futile, and they shut down. Now, the Baldwins here were actually sophisticated business owners, and they had a negotiated agreement with Atlantis, and there were multiple other offers coming in for the use of their river access. That's why Atlantis was paying for an option and then paying to extend the option. Now, the Baldwins also were represented by counsel during the transaction with Atlantis, and their attorneys are the ones who drafted the agreements. So there's always a bit of a deference or interpretation against the drafting party, as they had more control over what was being executed because they were the drafters. Now, the Baldwins also knew very clearly they were contracting with Atlantis, which was a startup company, and their operations were contingent upon getting that water permit. They were not contracting with Iafina, and again, they were represented throughout, and their attorney who drafted all the contracts did not require Iafina to personally guarantee. They did not require additional guarantees. The Baldwins knew who they were contracting with. There was no switching of hats. There was no subterfuge. Nobody was hiding. Ultimately, the Baldwins did not, again, require Iafina to be a party to the agreements. They could have. They could have asked it. Or they could have asked Iafina to personally guarantee performance of the agreements. They had counsel. They chose not to do that for whatever reasons. So the Baldwins failed to produce evidence that Iafina used Atlantis as a subterfuge. They failed to meet that second prong, that there was some sort of wrongdoing, some sort of unfairness that ultimately required piercing the LLC's veil, because they couldn't establish what is ultimately an essential element of their case, and they bore the burden of proof on that at trial because that was the second prong. They needed to meet it. They had the burden to prove it. Defendants Atlantis and Iafina were entitled to judgment as a matter of law. And ultimately, the Court of Appeals affirmed the bankruptcy court's determination that they granted the defense their motion for summary judgment.